We anticipate in the next 10 to 12 years, approximately 8 to 6 million Hispanics coming into the United States and 41 million Asians. You have been the majority minority for 400 years in this country. You have been the number 2 population for 400 years. You're going to get kicked out of being number 2. You're going to go down and become number 4. Now, common sense, even a third grade education would tell you, if you didn't get anything when you were number 2, you almost jumped ahead of me, but anyway, you can guess what you're going to get when you become number 4.
President Biden, do you support reparations?
Well, let me, since I haven't spoken on this, got a chance. Number one, the reason we're the country we are is because of immigration. We've been able to cherry pick the best from every single continent. The people who come here have determination, resilience. They are ready to stand up and work like the devil. We have 24 out of 100 children in our school today is Hispanic. The idea that we are going to walk away and not provide every opportunity for them is not only stupid and immoral, but it's bad for America. They are the future of America. Such systemic racism that has plagued our nation for far, far too long. I said that over the course of the past year that the blinders have been taken off the nation, the American people. What many Americans didn't see or had simply refused to see couldn't be ignored any longer. Those 8 minutes and 46 seconds that took George Floyd's life opened the eyes of millions of Americans and millions of people around all over the world. It was the knee on the neck of justice, and it wouldn't be forgotten. It's not white Americans' fault, but just a fact.
At the very same time that America refused to give the Negro any land, through an act of Congress, our government was giving away millions of acres of land in the West and the Midwest, which meant that it was willing to undergird its white peasants from Europe with an economic floor. But not only did they give the land, they built land-grant colleges with government money to teach them how to farm. Not only that, they provided county agents to further their expertise in farming. Not only that, they provided low interest rates in order that they could mechanize their farm. Not only that, today, many of these people are receiving millions of dollars in federal subsidies not to farm, and they are the very people telling the black man that he ought to lift himself by his own bootstraps. And this is what we are faced with. And this is the reality. Now, when we come to Washington, in this campaign, we are coming to get our check.
We are owed $104 trillion on the very low end, plus $735 billion recurring. This number does not include the cost of about 50 Black Wall Streets that were decimated, nor compound interest from 2017 when Sean D. Rochester's book, The Black Tax, was published, nor the cost of Black life, nor the cost of living increases, nor the war on drugs, nor the current day pandemic. The number I'm working with is for slavery, Jim Crow and ACCRUED ongoing systemic racism, oppression, and disadvantage in the country our ancestors built with their lives. If you believe in this number as I do and would like to join me in the fight for reparations, please email me at friendsofadostv@gmail.com. That's friendsofadostv@gmail.com. Good evening on the West Coast. Good evening in the mountain. Good evening in the central. Good evening on the East Coast. Thank you so much, guys. This is part 2, day 4 of my new series, Ida B. Wells 2.0, addressing anti-Black racism, which the Biden administration has neglected to weaponize George Floyd events to give protections to Asians. since I guess their assaults have increased since the COVID. Now, I'm not mitigating what's happening to them, but I'm saying what's happening to us has been over 400 years since before we were dragged here in chains. And so I created this series to keep the media attention on all of the atrocities happening to ADOCS. Since the mainstream media doesn't want to talk about that, they decided they want to pivot and try to make Black lives a non-issue, to deny us our justice claim, and to make us fourth-class citizens in the country our ancestors built with their lives. They've neutralized us economically. Now they're coming for our votes by weaponizing immigration against us. And therefore, I am teaching over here what we must do if we are to survive this ADOCS Holocaust that is ongoing. This month, I'm going to be focused on the George Floyd case, the Chauvin trial, because I, like many of you, are feeling very anxious and pent up, and we understand the stakes are very high. If this man walks, it is going to be open season on ADOCS. I highly recommend you get to the gun ranges and learn how to shoot. When you stay ready, you don't have to get ready. Let me jump to my article. The show is designed to give you bullet points because many of us have lives, children, husbands, other extended family, and we don't have time to sit up 7 hours a day to keep up with the events, but we want to be kept in the loop. And so daily, I'm going over the highlights. I missed yesterday because I had to go to the dentist and my mouth was numb, and I didn't want to be slurring my speech when I read to you and when I give you the way I see it in between what I'm reading. So I'm reading to you highlights from day 4 of the Chauvin trial. Paramedics and a retired surgeon described their experiences surrounding the death of George Floyd. A former Minneapolis police sergeant who was Derek Chauvin's supervisor on the day of his encounter with George Floyd was the final witness to take the stand Thursday during the 4th day of witness testimony in Chauvin's murder trial. David Pleger testified that the officer's restraint of Floyd should have ended after he was handcuffed on the ground and no longer resisting. This is how you know it's really first-degree murder. He intended to murder George Floyd. That's me speaking. Back to the article. The 2 paramedics who treated Floyd and a captain with the Minneapolis Fire Department who responded to the scene also testified, along with Floyd's girlfriend, Courtney Ross. Court adjourned. Friday set to be just a half day of testimony. That was today, which I will cover on Sunday. Moving on. Chauvin should have ended force against Floyd after he was cuffed and on the ground, supervisors said. Derek Chauvin's former supervisor said force used against George Floyd should have ended when he was handcuffed and on the pavement. When Mr. Floyd was no longer offering up any resistance, that should have ended use of force against him, retired Sergeant David Pleger told jurors. Pleger, who recently retired from the Minneapolis Police Department, testified that he reviewed all of the body-worn cameras of Chauvin and the 3 other responding officers, and that their restraint of Floyd should have ended much earlier than it did. Prosecutor Steve Schleicher asked Pleger, based upon your review of this incident, do you believe that the restraint should have ended at some point in the encounter? Chauvin's attorney, Eric Nelson, objected, and the attorneys had a private sidebar with Judge Peter Cahill. Cahill ordered the jury out of the courtroom, and Nelson argued that Pleger had not reviewed all of the evidence, such as witness accounts. The debate was primarily over how extensive of an opinion Pleger would be allowed to give. Once Floyd died on May 25th, the matter was deemed a critical incident, and that triggered a review by Internal Affairs, taking the matter out of Pleger's hands. Nelson argued that Pleger shouldn't be allowed to make a judgment on Chauvin's use of force. What? This officer, Sergeant Pleger, did not make this determination. He has not done a use of force review, Nelson argued outside the ears of jurors. He has not reviewed the entirety of this particular case. Cahill ultimately directed Schleicher to withdraw his earlier question, but said he could ask Pleger, do you have an opinion as to when the restraint of Mr. Floyd should have ended in this encounter? Which he did after the jury was called back into the courtroom. Pleger responded, when Mr. Floyd was no longer offering up any resistance to the officers, they could have ended their restraint. And that was after he was handcuffed and on the ground and no longer resisting, Schleicher asked. Correct, Pleger said. This gets at the heart of the prosecution's argument that Chauvin did not follow proper protocol in his restraint of Floyd. Restrained prisoners should be rolled on his side, Chauvin's supervisor said. A restrained prisoner handcuffed and feet secured must be rolled on their side so they're not deprived of oxygen, Derek Chauvin's former supervisor told jurors. David Pleger is now retired, but last year he was a sergeant and Chauvin's supervisor on May 25th when the officer encountered George Floyd outside of Cup Foods. A prosecutor and Pleger went over Minneapolis police policies and what officers should do when a suspect is put in the hobble position when both their feet and hands are cuffed. Former Sergeant Pleger said officers are instructed to roll a suspect on their side. It gets them on their side so they can breathe easier, Pleger said, so they don't suffer breathing complications. Pleger noted that this is the policy even if no officers are putting their weight on a prisoner, as was the case when Floyd was taken into custody. State asked about Minneapolis Police Department's policies on when to alert supervisor about an officer's use of force. Mary Moriarty, the former chief public defender of Hennepin County, explains that the prosecution is walking through the Minneapolis Police Department's policy on when a supervisor must be told about an officer's use of force. David Pleger, who recently retired as a sergeant with the Minneapolis Police Department, is testifying about the proper protocol. Pleger was supervising Derek Chauvin and the 3 other officers who arrested George Floyd last May 25th. Next, Minneapolis police sergeant who 911 dispatcher called after seeing officers restrain George Floyd takes the stand. The prosecution has called recently retired Minneapolis police sergeant David Pleger to the stand. Pleger was supervising Derek Chauvin and the 3 other responding officers last May 25th. A 911 dispatcher testified Monday that she called Pleger after she watched the officers pin George Floyd to the ground live in a security video. The dispatcher, Gina Scurry, said the officers restrained Floyd for so long that she asked someone whether her screens had frozen because it hadn't changed and was told that it was not frozen. Minneapolis fire captain takes the stand. Jeremy Norton, a captain with the Minneapolis Fire Department, took the witness stand Thursday afternoon in the trial against Derek Chauvin. He was the 4th witness called to the stand on Thursday. Norton was among the first responders who arrived at the scene of Floyd's arrest. Paramedic. Any layperson can do chest compressions. During a testy exchange, Derek Chauvin's attorney, Eric Nelson, asked Derek Smith, a Hennepin County paramedic who responded to the scene of George Floyd's arrest, about his actions in the ambulance. Smith testified that his colleague, who was driving the ambulance, had pulled over to assist him in performing chest compressions on Floyd in the back of the vehicle. Nelson questioned why Smith didn't take Officer Thomas Lane, who was fired a day after Floyd's arrest and is charged in his death, to perform chest compressions instead. Lane had traveled in the ambulance with the paramedics, and Smith testified he had directed Lane to deliver chest compressions on Floyd en route to the hospital where Floyd was pronounced dead. Why didn't you just have the officer continue to help you? Nelson asked. That's not what we do, Smith said.
Is it because he's not an EMT, Nelson asked. Any layperson can do chest compressions, Smith responded. There's no reason Minneapolis police couldn't have started chest compressions. That's not my question, Nelson shot back. My question is, he's not an EMT, correct? Smith said he did not know the levels of certification the officer in the ambulance had. Paramedic says he thought Floyd was dead when he assessed him at scene. A paramedic who responded to the scene of George Floyd's arrest said in testimony Thursday that he thought Floyd was dead when he assessed his condition at the scene. The Hennepin County paramedic Derek Smith said Thursday afternoon that he arrived to see 3 officers on top of Floyd. When he inspected the man, he said he did not detect a pulse from Floyd. I thought he was dead, he told prosecutors. Smith said he looked to his partner and told him, I think he's dead. I want to move this out of here. He then said he would begin care at the back of the ambulance. Trial resumes with testimony from a second paramedic. The trial has resumed after a lunch break with the second Hennepin County paramedic on the witness stand. The paramedic, Derek Smith, who was on duty last May 25th, said when he arrived on the scene, he believed George Floyd was already dead. Attorneys for George Floyd's family says jurors should look past his drug use. 2 attorneys for George Floyd's family said jurors should look past his drug use after his girlfriend testified Thursday about their shared opioid addiction. Me speaking, who, oh, by the way, is a predominantly white issue, and they've got all kinds of therapy unakin to the crack epidemic that they brought to our communities to decimate them for the preschool to prison pipeline, where many of our drug addicted were thrown into jail and couldn't afford to bond. They didn't get therapy. But the opioid addicted white folks get therapy and no jail time. Back to the text. In a joint statement, the lawyers Benjamin Crump and Antonio Romanucci said they fully expected the defense to put Floyd's character and struggles with addiction on trial because that is the go-to tactic when the facts are not on your side. Crump and Romanucci said they are confident the jury will see past that to arrive at the truth. That Floyd would have lived to see another day if Derek Chauvin hadn't brutally ended his life in front of a crowd of witnesses pleading for his life. Me speaking, he was living just fine. He was happy-go-lucky in the store. He seemed totally unaware if there was a counterfeit in his hand at all. He even sat outside the Cup Foods up until the cops accosted him with a gun to his face and arrested him. We want to remind the world who witnessed his death on video that George was walking, talking, laughing, and breathing just fine before Derek Chauvin held his knee to George's neck, they said. To my point, prosecutors called Floyd's girlfriend, Courtney Ross, to the stand and questioned her about Floyd's drug use in an apparent effort to head off the arguments from Chauvin's lawyer, Eric Nelson, that drugs could have caused Floyd's death. On Monday, before opening statements, Crump said the defense strategy relied on the same old playbook. They're going to try to assassinate his character. The fact that they found trace amount of drugs in his system is just a distraction, Crump said. The thing that killed George Floyd was an overdose of excessive force. Amen to that. Paramedic says Floyd's heart was not pumping blood when they tried to resuscitate him. A paramedic who was dispatched to the scene of George Floyd's arrest testified Thursday that Floyd's heart was not pumping blood as they tried to resuscitate him a few blocks away from the site where he was restrained. Seth Zachary Bravender, a Hennepin County paramedic, said Thursday that Floyd's heart wasn't really doing anything in that moment as they begin the process of trying to resuscitate him following the incident in front of Cup Foods. It's not a good sign for a successful resuscitation, he said. Basically, just because your heart isn't doing anything at that moment, it's not pumping blood, so it's not a good sign for a good outcome, he added. The paramedics in the ambulance then used a LUCA's device to do mechanical chest compressions on Floyd as his heart was not beating. Bravender testified that Floyd was not revived at any point. Floyd was ultimately pronounced dead. Hennepin County paramedic who was dispatched to the scene of George Floyd's arrest takes a stand. Seth Zachary Bravender, a Hennepin County paramedic, is on the witness stand after a morning break. Bravender was on duty last May 25th and was dispatched to the scene of George Floyd's arrest. Prosecution aired George Floyd's shortcomings as well as legal expert says. Prosecutors explained George Floyd's struggle with the drugs as well as possible, with an eye toward Derek Chauvin's defense that'll surely put blame on the victim, legal analysts said. Floyd's girlfriend, Courtney Ross, spared no details explaining their shared issues with opioids and even past overdose episodes. And uncomfortable as that might have sounded to Floyd's survivors, airing his drug struggles was a necessary legal maneuver by prosecutors, who I think are doing an amazing job, by the way. According to former federal prosecutor Joyce Vance, quote, "We know intellectually there's not a death penalty in America for passing a counterfeit $20 bill or for being a drug addict. But that's really the strategy that the defense has in mind here, is to plant in the jury's mind the notion that Floyd in some ways deserved what happened here," Vance told MSNBC following Ross's testimony. And so here they're able to talk about Floyd's drug addiction in a very human way, but also they're educating the jury about the fact, even if the drugs in George Floyd's system contributed in some way to his death, that importantly, he was brought back in earlier overdose situations with medical treatment, which wasn't provided here. Former U.S. Attorney Harry Littman said Chauvin's defense lawyer, Eric Nelson, could have made more from Ross's testimony with fewer questions. A cross should be very focused and make 2 or 3 points and out, Littman said. And instead, Mr. Nelson seems to be sort of meandering, repeating the direct, not highlighting what he wants to say, asking a lot of open questions. Me speaking, because he is shook. That prosecution is whipping ass and taking names. His goal should be make 2 or 3 points and sit down. But NBC News legal analyst Danny Savala said prosecutors should have brought out more bad stories of Floyd's drug problems to get ahead of the defense. I think the AG should have brought out a lot more of the drug use. It kind of looks like they were hiding it, Savala said. Anyone with opioid addiction has a lot of bad stories. Defense asked about friend providing drugs to Floyd. Derek Chauvin's defense attorney asked George Floyd's girlfriend a series of questions about who provided Floyd with drugs during questions about his opioid addiction. Attorney Eric Nelson asked Courtney Ross Thursday morning several questions about Maurice Hall providing Floyd with drugs. Hall was a friend of Floyd's who was with him on the day that he died. Hall was in the passenger seat of the car when police approached Floyd. Ross says she didn't like Maurice very much. She says she did not see Floyd purchase drugs from Hall with my own eyes, but speculated that he did. A cashier at Cup Foods testified Wednesday that Hall had tried to use a fake $20 at the store earlier in the day on May 25th, 2020, the day when Floyd died. Hall has filed notice that he plans to invoke his Fifth Amendment right not to testify in the case. I wonder what happened to him. How did he get away? That's interesting to me. I got to dig and do some research and bring that to y'all, family. Why prosecutors are having George Floyd's girlfriend discuss his drug use. Prosecutor Matthew Frank asked George Floyd's girlfriend, Courtney Ross, many questions about their shared opioid addiction that she said they struggled with throughout their 3-year relationship. And this is where me and Savalas differ. I don't think it's imperative to hear a ton of bad stories to demonize the drug abuse by George Floyd. She shared that they got addicted to opioids, her with a neck injury and him with a back injury. There's no need to make this about that. Cool, let's touch it, let's hit it, to destroy defense's ability to weaponize it against him and make his execution his fault. But we don't have to live there and get all the gore. It was gory enough. Haven't the people been traumatized enough? By calling Ross to the witness stand, prosecutors are attempting to not only humanize Floyd, but also establish he had a high tolerance for fentanyl. An autopsy determined that Floyd was intoxicated with fentanyl and had recently used methamphetamines. The defense has claimed that Floyd died from a drug overdose, underlying health conditions, and the adrenaline flowing through his body, not from being pinned under Derek Chauvin's knee for 9 minutes, 29 seconds, as the prosecution said Monday. That's the part that is the unmitigated gall of these white inferior glacier donkey race soldiers. He literally took his life while all the cameras were rolling and the bystanders were screaming. It was as if he was getting off on it. Prosecutors show no qualms in showcasing George Floyd's drug use. Prosecutors didn't hesitate showcasing George Floyd's opioid addiction, a drug struggle that's sure to be central to Derek Chauvin's defense, legal analysts said. Floyd's girlfriend, Courtney Ross, under the friendly questioning of Assistant AG Matthew Frank, explained how they both had issues with opioids. Ross admitted on the witness stand that she went to great lengths to secure various opioids for herself and Floyd. Minnesota prosecutors have no choice but to show these cards early to take the sting out of it before the defense talks about it, said Mary Moriarty, former chief Hennepin County public defender. An autopsy on Floyd showed evidence of fentanyl and methamphetamine use, and Chauvin's defense wants to show that factors other than the officer's knee could have caused the man's death. They are certainly reaching because he was living with whatever drugs were in his system and didn't start acting erratic until said events. It's better for the prosecution to detonate their own bombs and not let the defense detonate them, NBC legal analyst Danny Savalas said. George Floyd's girlfriend, Courtney Ross, 45, recounted how they both struggled with opioid addiction. She said they both struggled with their addiction to painkillers throughout their 3-year relationship. Floyd and I both suffer with an opioid addiction, she told prosecutor Matthew Frank. Both Floyd and I, our story, it's a classic story of how many people get addicted to opioids. She said they both suffered from chronic pain. Mine was in my neck, his was in his back, she said. We both had prescriptions, but after prescriptions that were filled, we got addicted and tried really hard to break that addiction many times. They attempted to work through it together, she said. Asked by Frank how long they struggle with addiction, Ross said, addiction, in my opinion, is a lifelong struggle. So it's something that we dealt with every day. It's not something that just kind of comes and goes. It's something I deal with forever. She said Floyd would take Oxycontin and oxycodone. They would purchase the opioids on the black market. She said there were times they would use opioids together. George Floyd's girlfriend testified Thursday that he seemed like a shell of himself and broken following the death of his mother in 2018. Courtney Ross, 45, said Thursday morning in court that Floyd changed after the death of his mother in May 2018. He seemed kind of like a shell of himself, like he was broken. Ross, who described Floyd as a mama's boy, added that she could tell he was devastated by the loss of his mother. He seemed so sad. He didn't have the same kind of bounce that he once did, she said. He loved his mom so much, she said through tears. She broke down in tears on the witness stand, recounting how they met and how she always called him Floyd rather than by his first name. Waitress Courtney Ross, 45, told jurors, it's one of my favorite stories to tell, explaining how they met in August 2017 at a Salvation Army shelter where he worked as a security guard. The father of Ross's son was staying at the shelter and wasn't coming down to see the witness, upsetting her as Floyd offered comfort. He said, "Can I pray with you?" said Ross, as she choked back tears. "I was tired. We've been through so much, my sons and I. This kind person, just to come up to me and say, 'Can I pray with you?' I'm alone in this lobby. It was so sweet. At the time, I had lost a lot of faith in God." Earlier in her testimony, Ross said she always called her boyfriend Floyd, much like his old Houston friends who also knew him as Floyd or Big Floyd. Ross was emotional from the time prosecutor Matthew Frank asked her how she met Floyd. Let me jump down. Christopher Martin, 19, who was a cashier at the store and lived above it, testified Wednesday that he flagged the $20 bill and that he suspected that Floyd was high, but that he was friendly and talkative. An autopsy determined that Floyd was intoxicated with fentanyl and had recently used methamphetamines. Martin said he accepted the bill despite a store policy that said the amount would be taken out of his paycheck because he didn't believe Floyd knew it was counterfeit. He also said he hadn't been trained by Cup Foods to identify a counterfeit bill. The color of the bill made him suspicious that it was fake, he testified. "I thought I'd be doing him a favor," Martin said. And that concludes my updates for day 4. I'm going to also share a little bit about, since I got a little bit of time, I got about 28 minutes left in the segment. I want to talk about Chauvin's past violence. Okay, hold on one second. Okay, I want to share this article with you guys because Chauvin's rap sheet is atrocious. So let's get into it. Derek Chauvin used force against suspects before George Floyd. The jury won't hear about 6 of those incidents. You're about to hear about them now. 17 complaints filed with Minneapolis police about Derek Chauvin. And these are the race soldiers that are allowed into our communities to execute us by government sanction, execute us with impunity, in an effort to gentrify our communities, is what I think. Six times in which prosecutors say Chauvin used force against arrestees. George Floyd's arrest was aggravated robbery in 2007. Did you hear me? 6 times in which prosecutors say Chauvin used force against arrestees. George Floyd's arrest for aggravated robbery in 2007. The jury considering murder and manslaughter charges against Chauvin won't hear about any of those incidents. Their verdict may be influenced as much by what they don't know as what they do. The system, y'all. They're able to bring up and use and weaponize George Floyd's drug addiction against him. But the prosecutors aren't allowed to weaponize Chauvin's record against him for a guilty verdict. The jury considering murder and manslaughter charges against Chauvin won't hear about any of those incidents. Okay, jumping down. Chauvin, a white former Minneapolis police officer, is accused of killing Floyd, 46, a black man We already know that. In the run-up to the trial, both sides sought to introduce evidence about Chauvin and Floyd's past actions. Prosecutors wanted to introduce 8 incidents involving Chauvin. Hennepin County District Judge Peter Cahill allowed 2. The defense wanted to bring up 2 arrests of Floyd's, including one in Harris County, Texas in 2007 that resulted in a conviction for aggravated robbery. Cahill allowed only a portion of Floyd's drug-related arrest in 2019 in Minneapolis. It's common for judges to make such rulings on what evidence can be introduced in a trial. The court wants to ensure that the jury doesn't punish a defendant for prior bad acts, as they're called. But the defense is able to weaponize George Floyd being drug addicted against him for his own execution by Chauvin. Jurors must evaluate whether Chauvin is guilty of what he is charged with: 3rd and 2nd degree murder and 2nd degree manslaughter. And my prayer from my Christ, my inner Christ to their inner Christ, is that he's guilty of all 3 counts and get the maximum of every sentence each of these charges holds. In criminal prosecutions, wrongful acts generally aren't admissible unless prosecutors can demonstrate that they implicate the defendant. The incidents are important to the case, and they won't unfairly prejudice the jury against the defendant. These wrongful acts, me speaking, do demonstrate an implication of defense. "17 complaints. Back to the text. Though police department records show 18 complaints filed against Chauvin over the course of his 19-year career with Minneapolis police, just 1 will be introduced at trial. Cahill's rulings make sense overall, said Ted Samsell Jones, a professor at Mitchell Hamline School of Law in neighboring St. Paul. The judge is letting in the most similar incidents for both sides, but overall, he's limiting the inquiry, trying to keep the parties and the jury focused on the charged incidents, Samsell Jones said. This isn't supposed to devolve into a free-ranging inquisition of Floyd's past, nor Chauvin's, he said. Prosecutors want to introduce 8 incidents in which Chauvin used force while on duty or was involved in an incident in which another officer did. 6 were deemed inadmissible by Cahill, who wrote in a court filing that the incidents weren't similar enough to the Floyd incident. Use of force is not similar enough? The judge concluded that prosecutors were improperly trying to show Chauvin's propensity to resort to unreasonable force. Breathe. Cahill bases decisions on what the jury would learn from the evidence and a review of the prosecution and defense filings. Those 6 incidents spanned 6 years. In 2014, Chauvin placed his body weight on the upper body and head of a man to handcuff him, according to prosecutors. And that's inconsequential to what he just did to Floyd, to finally take his life. He's been practicing. In February 2015, Chauvin tried to restrain a man by putting pressure on his lingual artery, which is below the chin bone, prosecutors wrote. Chauvin pushed the man against the wall and applied a neck restraint. But Cahill says no to this evidence being used It's not similar enough. Once the man was face down on the ground, Chauvin handcuffed him and kept him there until backup arrived. In April 2016, Chauvin restrained the man who would not follow instructions, placing his hands around the man's neck and applying pressure to both sides. According to prosecutors, as Cahill says, it's inconsequential. It's not the same. It's not parallel. Family, brace yourself for the worst and be pleasantly surprised if he gets the maximum sentence and guilty verdict for all three charges in general population without the possibility of parole. This is Cahill now, the judge not allowing this to come in. The officer forced the man backward onto the sidewalk, handcuffed him, and walked him to a squad car. A small crowd of concerned citizens gathered to watch, prosecutors wrote. The man complained of asthma and paramedics were called. Target practice. And he got 19 years on the force. And as I mentioned in my earlier video, Asian folks' median income is $87,000. White folks' median income is $65,000. ADOCS median income in Black immigrants is $41,000. Where are these race soldiers? In the Asian communities? In the white communities? Or in the ADOCS and Black immigrant communities? All the incidents involve resistance from or a struggle with a suspect. Some involve Mr. Chauvin using his body weight to control an arrestee. Some involve a neck restraint, Nelson argued. This is simply insufficient to show a marked similarity between the pro-offered incidents and the charged offenses. That's the defense attorney, Nelson. In September 2017, Chauvin responded to a domestic assault call with another officer and tried to arrest a 14-year-old boy. When the boy resisted, Chauvin applied a neck restraint and rolled him onto his stomach. Chauvin stayed in the same position, his body pinning the boy to the floor beyond the point when such force was needed under the circumstances, prosecutors wrote. In March 2019, Chauvin told a man to move away from a person reporting a stolen vehicle to him and another officer. When the man refused, Chauvin walked over and grabbed him. The man pulled away, flailing his arms and struggling with the other officer. Prosecutors wrote. Chauvin sprayed mace at the man's face, the same way Chattel threatened the bystanders and eyewitnesses of that race soldier Chauvin taking the life of George Floyd. The other officer told the man to lie on the ground, but he kneeled instead. Chauvin applied a neck restraint, forced him to the ground, and sat on the man's back, pinning him so he could be handcuffed. Chauvin restrained the male in this position beyond the point when such force was needed or reasonable under the circumstances, the prosecution argued. The defense said Minneapolis Police Department supervisors found Mr. Chauvin's application of force to be in conformity with his MPD training, authorized by law and MPD policy, and reasonable. In July 2019, Chauvin and another officer responded to a domestic assault. When the male suspect dropped his arms to his side, Chauvin grew concerned about his access to knives, prosecutors wrote. Chauvin grabbed one of the man's arms and kicked his lower midsection to back the man away. Because Chauvin thought the man had tensed up, prosecutors wrote, he applied a neck restraint. The man made a brief snoring noise that indicated he had gone unconscious, and Chauvin handcuffed him. A supervisor responded to the scene and deemed Chauvin's force reasonable, authorized, and appropriate under the circumstances, the defense wrote. But were there knives on his person because he dropped his hands? Prosecutors argued those incidents show Chauvin regularly resorted to force even when it wasn't necessary. In the state's view, they wrote, Chauvin operates in disregard for the particular circumstances of a given situation in determining appropriate reasonable force and simply fully restrains the suspect with no regard for their well-being until he can turn them over to someone else. Cahill disagreed. The judge. The real purpose for which the state seeks to introduce evidence of 8 prior incidents is simply to depict Chauvin to the jury as a thumper, an officer who knowingly and willingly relishes mixing it up with suspects and routinely escalates situations and engages in the use of unreasonable force, the judge wrote. Is that not who the hell he is? Cahill ruled that any value of introducing those 6 incidents to prove Chauvin's guilt in Floyd's death would be outweighed by the potential to unfairly prejudice the jury. America is on trial, along with the 4 white inferior glacier donkey race soldiers. Jurors will hear about 2 incidents with Chauvin. The 2 incidents, it jumped, hold on, family. The 2 incidents Cahill did allow to be introduced to trial involved one in August 2015, in which Chauvin watched officers move an arrestee to a recovery position, and one in June 2017, in which Chauvin used excessive force in arresting a woman at her home, according to Cahill's summaries of the incidents. Which one bears more weight to get his ass convicted? The 2 that he's allowing, or the 6 I just read you? In 2015, Chauvin joined other officers helping a suicidal, intoxicated, and mentally disturbed man, prosecutors wrote. The officers struggled with him and used a stun gun. The officers got handcuffs on the man and put him in a side recovery position according to their training. They called an ambulance, and Chauvin rode with the man to the hospital. The officers were told by medical professionals that if they had waited any longer to get him help, the man could have died. The officers involved, including Chauvin, were recommended for an award. I wonder what color the man was. In 2017, Chauvin went to arrest a woman at her home for allegedly trying to strangle her mother with an extension cord, prosecutors wrote. As she walked by, Chauvin grabbed one of her arms and told her she was under arrest. She tried to pull away, and Chauvin put a cuff on one wrist. As she tried to twist away, he pulled her face down to the floor, kneeled on her body to pin her, and finished handcuffing her. When she refused to stand up, Chauvin and another officer dragged her outside with her feet on the ground. The officers put her face down on the sidewalk. I got 10 more minutes. Guilt, regret, helplessness. Watching George Floyd die had a profound impact on witnesses. Though the woman wasn't resisting, prosecutors wrote, Chauvin kneeled on her, pinning her down while another officer moved the squad car closer. Chauvin told the other officer to apply a hobble restraint, which links someone's wrists and ankles. That is a hog tie. Adjust your volume if I'm too loud. I'm hotter than fish grease. I get loud when I'm angry. Chauvin's conduct in kneeling on the woman during this entire time was more force than was reasonably necessary under the circumstances, the state argued. Chauvin's attorney Nelson argued in court filings that this use of force was cleared by the police department. There was nothing unreasonable or unauthorized about Mr. Chauvin's actions during this incident, nor is it at all similar to the George Floyd incident, Nelson wrote. The prosecution has said it has body-worn video of the incident and believes it shows behavior similar to Chauvin's handling of Floyd. Defense argues 2019 arrest of Floyd is similar. Jurors will learn about an incident in May 2019 captured on a body-worn camera in which Floyd allegedly swallowed a pill when officers approached him. Police responded to information about illegal narcotics activity. An officer pulled a gun on Floyd, gesturing for him to put his hands on a car dashboard. Floyd begged the officers not to shoot and then cried as he was handcuffed and patted down. Officers found oxycodone pills on him and in the car. Floyd was admitted to a hospital for accidental drug ingestion. The defense argued Floyd's behavior is part of a pattern. When approached by police, Floyd, placed drugs in his mouth in an attempt to avoid arrest and swallowed them, Nelson wrote. When interacting with police, he engaged in diversionary behavior such as crying and acted irrationally. Because he knew they were going to murder him eventually, and on May 25th, 2020, his intuition, his erratic behavior was made manifest. The defense argued Floyd's physical condition during that incident may support its contention that Floyd died not from Chauvin's knee on his neck, but a combination of the struggle, medical problems, and drugs. That's a stretch. It's such a stretch, it's immaterial. Cahill agreed to allow some evidence from the arrest in 2019 because there are similarities to the incident that ended with Floyd's death. So you're going to allow this, but not the most compelling cases that parallel what happened to Floyd on the prosecutor's side. There is a modus operandi to conceal drugs in part by ingesting them, Cahill said in a court hearing, but also doing so in a very stressful circumstance that is being pulled out of a car at gunpoint in handcuffs. Only a portion of video of the 2019 incident will be shown to the jury, starting with officers approaching Floyd in the car and ending when he is in handcuffs. A photograph of pills found in the crack of the car's seat is also admissible, Cahill ruled. Being addicted to drugs does not warrant your execution by state-sanctioned race soldiers who've got a 19-year history of similar oppression of the people, the poorest of us, ADOCS. The jury will not hear a recording of paramedics' conversation with Floyd or his emotional behavior, including him calling out for his mother. The paramedic told Floyd he had to go to a hospital because of his high blood pressure or he could suffer a heart attack or a stroke. Cahill will allow the paramedic to testify about the amount and kind of drugs Floyd took and why the paramedic recommended Floyd go to the hospital. The whole point here is we have medical evidence on what happens when Mr. Floyd is faced with virtually the same situation. Confrontation by police at gunpoint, followed by a rapid ingestion of some drugs, Cahill said. And that's not trying to swing the verdict to a not guilty before the jurors. We don't have the benefits, obviously, of medical vital signs of May 25th, Cahill said. The May 6, 2019 case is relevant only to that extent. The defense argued that Floyd took drugs before he was restrained by Chauvin. Floyd had fentanyl and methamphetamine in his system when he died, according to a toxicology report. A conviction in Texas. Cahill did not grant the defense's attempt to present evidence of an arrest in August 2007 in Harris County, Texas. According to the defense's description of the incident, Floyd dressed up as a water department employee and forcibly entered a home to steal drugs and money. During the robbery, Floyd put a gun on a woman's abdomen, allowed her to be pistol whipped by an accomplice, and demanded drugs and money, the defense wrote. Floyd was convicted of aggravated robbery with a deadly weapon, the defense wrote. Why should that be able to come in? He did his time. How will the jury interpret prior incidents? Mary Moriarty, a former Hennepin County chief public defender, said she believes Chauvin's prior incidents are more damaging to the defense than Floyd's arrest is to the prosecution. Moriarty said she is concerned the jury could misuse the 2019 incident, concluding there's a pattern to Floyd's behavior when dealing with police, where the Chauvin is guilty of murder is not tied to Floyd's propensity to be ingesting drugs or to be arrested by police, she said. Joe Friedberg, a longtime Minnesota criminal defense attorney, said he believes Floyd's behavior during the 2019 arrest will influence the jury because he is acting exactly the same way. Moriarty said Cahill will give jurors instructions explaining the limits of the evidence. As for Chauvin's prior acts, Moriarty said, you're not allowed to use that kind of evidence to say Chauvin always does this. He's a bad guy. This is how he interacts. But it is how he interacts. That concludes my article, family. Let me see what you got to say before I pray us out. Ooh, to Jesus. ADOS Truth. Thank you for joining the live. It's buffering. I'm so sorry to hear that. Teresa Moses, welcome to the live. Hello, Angela Nirvana, Dayton, Ohio, ADOS. Nice to see you on the live, family. Cynthia Blaine, nothing could justify the amount of time that Chauvin kept his knee on his neck. Nothing. You're absolutely right, Cynthia. Bajtosh Sampson, welcome to the live, my love. Bet Mass, welcome to the live. I want to thank you for those who have not yet typed your presence in the chat. Welcome to the live, one and all. Please like, share, subscribe on YouTube, Facebook, Twitter. I've got the Clubhouse open because people were asking, who am I? Who is this woman that now uses ADOCS, who is a part of the reparationist movement, does a show called The Reparationist Perspective? I am a co-founding member of the ADOCS movement, the SoCal chapter. Proud of that. But we had a parting of ways on how I like to move. I like to work with allies, immigrants, and I like to work on everything. I don't want to be told how to move for my people. So I am proudly going it with my group who works and supports me in the Equity Advocates PAC to get the lames out of office and replaced with full-chested reparationists on every level of government until they cut the checks in the trillions over multi-generations. Because as you can see by the George Floyd case, dollars bring dignity and being poor makes us a target. My other ask of us is to wrap our minds around what Dr. Charles Morris recommended and suggested when Teddy Roosevelt dishonorably discharged 167 Buffalo soldiers who were wrongfully accused of murdering a second white man after being quarantined in their barracks for being wrongfully accused of murdering the first. We had already delivered Teddy Roosevelt the vote. Dr. Charles Morris said, you shot us when our guns were empty. And for that, we're going to return the same by delivering a blue top of the ticket and a red Congress to protect the Black South. I'm asking of ADOCS to weaponize and allies to weaponize the only commodity we've got as a wealthless group, as the anchor of white inferiority capitalism in this country that our ancestors built with their lives. I'm asking for a red top of ticket, henceforth every election cycle, and a blue Congress to protect the over 53% of American descendants of chattel slavery who rely on government assistance by design of institutional systemic racism until they cut the checks in the trillions over multi-generations. All of what they killed us for and have stolen from us, that reparations is for slavery, Jim Crow, and accrued ongoing systemic racism, oppression, and disadvantage in the country our ancestors built with their lives. I see a couple of people waiting on me in the clubhouse. I'm going to have a conversation over there if you guys want to join me. Anti-Black racism, the Chauvin trial. I'll be back on Sunday with you guys live here on YouTube, Facebook, and Twitter under the reparationist perspective. 6 o'clock, we'll be doing day 5 and unpacking the highlights of day 5 today. And we're also going to go into my other new segment, Dear Immigrants, because of ADOCS, why you should be an ally in our fight for social and economic justice. And with that said, I'm going to pray us out over here so I can play with my folks in the clubhouse. I want to share with you, let me share my prayer protection over you, that the light of God surrounds us, the love of God enfolds us, the power of God protects us, and the presence of God watches over us. Wherever ADOCS and its allies are, God truly is, because, family, you are the face of God. You are the voice of God. You are the body temple of the Spirit of the living God. Until tomorrow. That's not Sunday. Sunday's Easter. I'm taking Sunday off. So tune in tomorrow, 6 o'clock Pacific Standard Time. And then back-to-back shows, 6 to 7 and then 7 to 8 for day 5 under the Ida B series 2.0 anti-Black racism. And at 7 o'clock Pacific Standard Time for Dear Immigrant segment because of ADOCS. Thank you so much for watching. Know that I love you, Black family. I love you strong. Peace. I'll see you in Clubhouse. Come on over, join us. Join the after party.